My name is Scott Herndon, and I live near Sandpoint, Idaho. I appreciate the time this morning. I would like to address constitutional issues that Mr. Kanzadi raised, and I'll start with the Idaho Constitution, which talks about an unalienable right to life in Article 1, Section 1. And so my question for the committee is, where in the Idaho Constitution does it authorize the legislature of the state of Idaho to permit the killing of children that are conceived in rape and incest? So Alabama and Arkansas have passed bans on abortion. Amendments were proposed to those bills to accept rape and incest alleged conceptions, and both of those legislatures rejected those exceptions. Since we do not have constitutional cover for those exceptions, I don't see how this body can abide by the Constitution and allow those children to be permitted to be killed. So I would urge this body to amend this bill to get rid of the rape and incest exception. Also, in Roe v. Wade, Blackmun criticized the state of Texas for the unequal penalties in their anti-abortion laws before 1973, and we're committing the same sins in this bill by not treating abortion as a homicide, which right now we have IDOC inmates that are serving life sentences for killing preborn children. We also have exceptions that we're only holding the licensed healthcare professional responsible, and 42% of the abortion market is chemical, where these days there may not be a licensed healthcare professional in the state that's prescribing RU 486. So we're missing most of the abortions that would happen. My final opposition to the bill is in the trigger of the effective date of an appellate court. There are 38 decisions of the United States Supreme Court affirming the fictitious right that a mother has a right to kill her child under the 14th Amendment, which was passed after the Civil War and had to do with the freed slaves obtaining their rights in the states. And the marijuana legalizing states have figured out that the way to deal with a wrong Supreme Court opinion, 36 states after Gonzalez versus Raich, a Supreme Court opinion of 2005, decided to ignore the Supreme Court because they did not see the constitutional authority of the court to outlaw marijuana. And here we are appealing to an appellate court, which is only going to obey the Supreme Court. And the Supreme Court has drawn a clear line in the sand that states may not ban abortion before 6 months gestation. 38 decisions over 48 years, the last one in June of 2020, written by Chief Justice Roberts. He wrote about stare decisis. Sandra Day O'Connor wrote about that. The appellate courts are going to follow precedent. I think our lawful action is to follow the marijuana legalizing states, ignore and defy. Legislatures make laws, not courts, and that's the only way we're going to make any steps forward toward ridding our state of legal abortion. So
Thank
I
you,
would
Mr.
urge
Hendon.
the committee
Your time
to
is
consider
up.
those 3 points.
Your time is
Thank
up.
you.
Thank you.
Appreciate it.
Thank you. Misty, are you there? Is she there?